This conference will now be recorded.
Yes, we believe that someone to be able to handle disputes should be capable of analyzing and synthesizing disputes. So the specialist is someone who can navigate and direct parties and clients to processes that include negotiation, mediation, arbitration, and litigation online. So the term digital actually refers to the online processes, but the dispute resolution refers to anything and all the processes that address the resolution of disputes. So for us, it's like having a new term, a new professional identity, and it's not just a title. So it can involve advanced technologies and processes such as machine learning, artificial intelligence, and cognitive computing, which are being developed and promoted to resolve specific types of disputes. Next slide, Rahim, please. So we believe that the integration of information and communication technology introduced a need to identify specific recognized competencies vital for professionals practicing in this field. And we believe that there are two main categories in skills: the digital skills and the skills that have to do with the digital process. So there are general skills that include, but are not limited, of course, to ethical obligations, to neutrality, to the awareness of potential bias, conscious and unconscious, and of course the confidentiality, all the skills that we are all of us familiar so far. And there are, of course, skills related to technology. So for someone to name himself as a digital dispute resolution specialist should have some skills that are related to, of course, basic computer skills and basic mobile computing skills, to be able to work with platforms, setup, operation, and troubleshooting, to have the ability to manage efficiently any technology challenges, and of course, to have the ability to use the technical equipment and environment, like, for example, lighting, sound, distractions, and all that, in order to deliver a high quality experience to participants of this respective process. Also, it has to have the ability to convey clear and effective messages in verbal and non-verbal communication. And of course, to have skills related to the digital process before, during, and after the mediation.
Yep. Thank you, Zoe. So moving on to what are the benefits of digitalization in the dispute resolution world. And one of the first aspects that is being mooted globally, and especially in the countries that we have been working in the South Asia part of the world, East Africa, and even parts of the Far East, is the access to justice, where the courts are unable to deal with the backlog, where there are issues of corruption, where there are issues where people are just physically unable to access buildings and services due to the fact that they are either in a particular poverty category or just are unable because of literacy and other issues to access. And one of the most interesting aspects of the United Nations Sustainable Goals is access to justice under Rule 16. And what we're seeing, and we'll see some examples of this later on, is that digitalization has huge benefits on access to justice. The second huge development is that your clients and parties of tomorrow are going to be young people. And young people don't see a dichotomy between digital and non-digital. They're only going to be living in the digital world. And so in order to access this group of people and to ensure that they understand the benefits of resolving their disputes, an offering in a digital mode is critical to your success and society's understanding of success. The third thing is demographics, and this is linked quite strongly to the idea of young people. And if you begin to look at continents, at Africa, and even the subcontinent of India and in parts of Asia, demographics will tell you that the mean age of society in those countries is anywhere between 17 and 21 years old. That is an incredibly young number, or younger group of people who will not tolerate the delays, the inaccessibility of traditional methods of dispute resolution. And if everything is online, if buying your cinema tickets are online, if your airline tickets are online, why can't your resolution of disputes be online? And we'll come on to the different modes that take place. Again, to the point at the beginning on access to justice, those with disabilities, now you make it a new term of accessibility. We're not talking about accessibility of a building with a ramp for people in a wheelchair. We're talking about real accessibility online in a way that gives them the ability to fully engage in the process. Efficiency. I mean, the word speaks for itself. The speed at which you can do these things, the connectivity, and of course we are dependent on the internet for all of the digitalization services, but of course they have huge impact. Lower costs. This is a huge, huge issue in the COVID-19 and post-COVID-19 era, is will people have the money to go and access the traditional services and pay vast amounts of money for registering their disputes, to paying their legal representatives, and the delay in which it will take to get these results. I fear that digitalization is only the way forward for lower costs. And then the final interesting point is instant decision making. And we're not talking about someone telling them what to do either, but decisions that they can be part of, that they can shape and that they can be an architect of. And so if you look at all of those points together, the benefits far outweigh many of the disadvantages that come with digitalization. And there are a few, but these are incredible, and I can see that these are only going to grow. And why will the DDRS role become the new normal? And many of you will be aware of a paper written by Mark Prensky in 2001, which was termed Digital Native versus Digital Immigrant. And this was a seminal paper in 2001. You know, we're entering a new century at the time, the rise of digital devices. Believe it or not, the iPhone hadn't come out yet, but there were lots and lots of services online. The internet was clearly around. We were using email a lot more. And Mark's paper took a look back at the previous 20 years and looked forward at the next 20 years, and was analyzing trends and predictions. And people thought he was too ahead of his time. He hadn't got the future really understood. But if you go and read the paper now, you would almost imagine that the paper was as relevant as it was in 2001 to what it is today. Digital is no longer a choice. And I'd like to give you an analogy of when online shopping happened. And people would have an online shopping experience, and then people would complain that, well, you know, I don't like it because I can't feel the cloth, or I can't hold the goods in my hand, and I want to see it before I buy it. And then they got to a point where organizations like Amazon and eBay and Alibaba and many others around the world, who then offered free return services and the whole ability to engage online. And now digital is just a choice. You can go to the shops or you can go online. Neither is seen as subservient to the other. They are now equal in what they do. And for some, they love it, and for others, they don't. And that's absolutely what I think is going to happen when we move into the digital dispute resolution landscape. The third huge development is legal education. If we look, and as an organization currently right now, we are, after this webinar, in fact, going back onto training in the UK, trainee barristers who are leaving their legal qualifications with a qualified mediator qualification. They are learning about arbitration, they're learning about negotiation. This generation coming through, and probably for the last 7 or 8 years, from North America to Western Europe and now into Africa and Asia, these young lawyers don't just look at disputes through the prism of litigation, but they look at the prism of resolving the disputes at the most appropriate way, given their local cultural and technological landscape. And the prediction is that the role lawyer in itself will become defunct. And we only have to read some of the great books written by Richard Susskind from the UK, who talks about the future of lawyers, the future of doctors, the future of other professions. And he starts to help us understand that digitalization has a huge impact. Artificial intelligence, Zoe mentioned that earlier. Here's an example of the computer Watson by IBM that can produce wills in languages and different legal systems within seconds, better than any human mind can, as long as you input the data. And that's the game changer. We are talking about services that we would otherwise traditionally pay vast amounts of money for, take days and weeks to resolve, can now be done simply by going online and without talking to a human being. Therefore, technology and online dispute resolution are completely normal and will remain the norm. And the final thing is about augmented dispute resolution and artificial intelligence. And I've mentioned the Watson computer, but what we're looking at now is a lot of augmented processes coming together to give you the feeling that you are in a very formal, structured process, and yet flexibility underpins the whole idea of becoming or allowing yourself to engage in a dispute resolution process. And so for the reasons that we mentioned above, I'm very comfortable to tell you that the DDRs will become the new normal of tomorrow's dispute resolution people. And then we talk about the term ODR, and there are many types of ODR. The definition that we have in front of us, where technology facilitates the resolution of disputes through a combination or individually through negotiation, mediation, or arbitration. And in a short while, Zoe will take us through some examples of ODR, especially in the European Union. But if any of you have ever bought any goods from any of the major online retailers, and you've had an opportunity to return it because it wasn't fit for purpose, or that it was the wrong size, when you go back and press the return button and go through the process of complaining, there is no human being at that point listening to your problem. And some of these large organizations have 27 layers of digital responses, artificial intelligence, before a human being may be involved in your dispute. And so that's one side of pure technical ODR. And then the other form of ODR is where human beings are involved very much at the forefront, but technology plays a fundamental role in bridging the gap of distance, in bridging the gap of time, in bridging the gap of cost. And I think that's a really nice segue for me to hand over to Zoe on the next slide.
Yes, thank you, Rahim. So we believe that even after the crisis subsides, we suspect that our global society will never go back to the way it was before the outbreak. But the main reason for the digital transformation ADR services is presenting is unrelated to COVID-19. And as Rahim mentioned, court systems around the world are largely broken. According to the OECD, more than 4 billion people live beyond the protection of lawyers, the law, and courts. And in some countries, as you might know, the backlog is staggering. There are 80 million cases in Brazil and 30 million cases in India. Even in advanced legal systems, the process is generally only understandable to lawyers, is too expensive for most, and civil cases take far too long. So there is an acute problem of access to justice that we mentioned, and hardly anyone anywhere can afford to take legal action through public courts. It is increasingly unaffordable for large businesses too, so many practices and procedures are arcane in today's digital societies. So we believe that technology is the fourth party now in any dispute. We have the two parties involved in the dispute. We have the specialist who is helping the parties to resolve their dispute, but technology now is the fourth party. And we have little doubt that technology can provide a sustainable set of solutions, but we have to deploy the right systems. So many technology advocates believe greater efficiency can be achieved by automating and streamlining conventional ADR services. And although this is very well intentioned, this approach is misguided. The challenge instead is to develop systems that deliver ADR services in ways that were previously impossible, or even we couldn't even imagine. So the point is not just to computerize current practices. The great power of technology lies in transformation and not in automation, as Richard Susskind mentioned. So the rise of technology. Rahim, could you please move to the next slide? Thank you. So the rise to technology, of course, started with the internet, but we had the smartphones. We can mediate, we can arbitrate, we can resolve our disputes through apps. We have the voice recognition, of course. Everything is so quick and so direct. 4G and 5G soon. Speed and connectivity in incredible speeds, and Wi-Fi is almost everywhere. Virtual reality and augmented reality that Rahim mentioned. And of course, you have this epidemic problem that might come back soon and might actually force us to have ODR as the only resolution method. So some examples, if you can, Rahim, move forward, of ODR resolution evolution, as we like to say, is that already, of course, and they're moving ahead, is the ADR ODR platform, and we will share some details on that. The Information Technology Act in India regarding e-commerce and e-governments, and in many countries in the world, e-justice is moving very fast. We have SAMA and paperless contactless courts in South Africa, and of course, the well-known to all of us who are in the EU, the WIPO platform for resolving IP disputes. These are, of course, some examples. There are many other areas where ODR evolution is happening all over the world. So regarding the EU ODR reform, the European Online Dispute Resolution Platform is provided by the European Commission to make online shopping safer and fairer through access to quality dispute resolution tools. So if you are in the EU, Norway, Iceland, or Liechtenstein, you can use it to find the best solution for your consumer problem, to discuss a solution directly with the trader concerning your problem, or to agree on a dispute resolution body to handle your case. The ODR platform is not connected to any trader, and you can use it in all EU languages in EU. So alternative dispute resolution bodies have to meet strict EU quality criteria, which guarantee that they handle your dispute in an effective, fair, independent, and transparent way. And most of them can help you free of charge or at a low cost, and they usually reach an outcome within 90 days. This is the maximum. Under EU law, you can use these bodies to handle all contractual disputes you may have with a trader established in the EU. So alternative dispute resolution can be used for any market sector, such as transport, banking, telecoms, energy, electronic goods, household appliance, car rental, or dry cleaning. And if you have a dispute with a trader in an EU country over goods or services you bought online or maybe offline, you can use the EU online dispute resolution site. So this website is available in all EU languages and is free of charge. So you can submit a complaint through the EU online dispute resolution site. You and the trader will need to agree on the alternative dispute resolution body that will handle your dispute. And each body has its own rules and procedures, possibly including fees. And all this process is taking place online. All the negotiation through this process is taking place online via this platform, which addresses actually 500 million consumers in the EU. So this is a huge, huge development regarding consumer disputes in the EU. Rahim?
Yeah, thank you very much, Zoe. And I think Zoe and I were very heavily involved in 2015 in the development and the application of the new directive in different parts of the world. So in the UK, I was involved when we were a member of the EU, and Zoe also runs a certified body within Greece that can handle these disputes. And if you think about 450 million people in the European Union who are using this service every single day when they have those disputes, and it really encourages the businesses to find really creative ways to help resolve their disputes with their clients, but everything is online. And if you are not somebody who enjoys the online world, then you're unable to participate and get benefit from such an important platform. Now we move to India, and there are two interesting examples that I wanted to share with you. And the first is where a country like India, which has such a diverse and pluralistic society of 1.1 billion people, that in 2000 and a few amendments as well through to this act, began to realize the importance of recording digitally and digital signatures to be binding amongst its people. And we are seeing more and more countries around the world fall behind the idea of digital signatures, digital records, digital contracts. And there's a very interesting question about the enforceability of agreements that come from different ODR processes. And I may come to that in a moment, but the first thing to say is that a lot of online mediation, where parties come together and get a deal, whether it's on a video conferencing platform or a structured non-video conferencing platform, a lot of e-documentation is used, A, to record it, so it is technically a binding contract. But secondly, and more importantly, we now have the Singapore Convention, which we can take on a bit later, that talks about the enforcement of mediation agreements globally, and also we have the New York Convention. So I'll come on to those. But India as a big, powerhouse of people and opportunity is really driving this way on the digital understanding of disputes. There's an organization called SAMA who are a young ADR organization, but began life as ODR Ways. And I want to share a story because I met the founders of this organization at 2 o'clock in the morning when I landed in Calcutta many years ago, when I arrived for some training. And on this journey, 2 young law students were explaining to me what they were going to create with ODR Ways. And they had realized that having a Zoom conferencing or GoToMeeting conferencing facility for the majority of the Indian people may be too far in terms of data, in terms of having the right device. And they had created 2 very innovative ways of mediating online disputes. One was using WhatsApp where available, and 2 where people didn't even have a smartphone but just a normal phone. And this term that you may have heard a long time ago and not heard recently is you could give a missed call to the provider who would then call you back and help you resolve your dispute through the telephone. And just looking at the innovation that is existing in different parts of the world, it became SAMA. It has got funding from private organizations as well as some state organizations, and really taking a shape that says 35, 36 million cases that are pending in the Indian legal system will not give access to justice to the ordinary person. We need to find another way. And for me, this is where civil society starts to play a real role in helping develop processes that meet the needs of the people. Moving on to Africa, and there are lots of different things happening, exciting things happening in Africa, but an example is South Africa, which is now going paperless after a very, very successful pilot project. And one of the most interesting ideas that the government of South Africa was excited by was it began to meet the United Nations Sustainable Goals, particularly around the rule of law. And many of you in different parts of the world will know what I mean when you say that if you're in a city, we think the city are the modern folk who have smartphones and iPads and tablets and laptops. And the more rural we go, the difficulty of Wi-Fi and internet. But in fact, the more rural you go, there may be not as many devices, but there is still 1 or 2 devices that access the internet, that give you access to opportunities. And so this paperless court about filing your cases through a smartphone, receiving papers back through a smartphone, even having some of your hearings on a smartphone. This was all pre-COVID-19. And then Western countries where COVID-19 hit, UK, France, Germany, US, Canada, all had to suddenly go into this immediate, urgent online hearing center. And for many individuals, lawyers and judges, this was very uncomfortable. They didn't have the right technology, the right kit. They weren't even aware of how they would come across on a video platform. Where are tomorrow's disputes going to come from? And if you look at WIPO as an organization, the World Intellectual Property Organization, for many years, they've been spending a lot of time and effort in investing in professionals to be on their arbitration and mediation centers. And if you look at the disputes of tomorrow, more and more of these disputes will have a technological stroke intellectual property angle. It is inevitable. And if you look at the numbers that they're producing, and I urge you to have a look at their outfit and their organization and what they do. People are readily willing, because where do you go? The whole challenge with intellectual property and technology disputes between countries is which country takes precedent in terms of law. What court do we go to? Which language is that operated? The minute you take it away from the individual nation states and put it into a cross-border understanding in a private setting, you have a whole different fit-for-purpose technological offering that allows people to engage fully in that process. And if you visit their website, they have actual examples of cases that have come from different parts of the world that have been fully engaging. And we think that more and more of the disputes of tomorrow will be of this nature. And so a DDRS not only needs to know how to navigate around the options and the platforms, but also understand what's the vocabulary around technology? What's the vocabulary around the disputes within a technological space? Zoe?
So yes, in summary, and of course we didn't have much time, we would say that DDRs and have all these skills is something that we definitely need. So this skill acquisition is essential, and since Generation Z is here and they live with this new reality, we believe that we can help you to get ready for this revolution. Rahim?
Yeah, and in order, we have a very special announcement to make today, and we'll be making this public as we move forward. But looking at the future, we will be launching a diploma in digital dispute resolution. And this diploma is effectively individuals who have the core competencies of a dispute resolution specialist, but particularly with a focus on providing those skills in an online setting. So mediation, arbitration, litigation, negotiation, but even online dispute resolution. And we are in talks with several international universities who want to collaborate to create a master's level program for graduates of our courses, because we believe that the DDRS is now no longer a choice, but the only option to ensure that you are not sidestepped from the development of future technology and the future of dispute resolution. And as the previous slide said, Gen Z is only going to look for those that can handle their disputes efficiently and in an online manner. So that brings us towards the end of our presentation formally. And we'd like to thank everyone for listening to us, but particularly the DIFC Academy for giving us this platform. And we do have an offering coming up in July on our first mediation course in Dubai. So that's very exciting with the DIFC. And I think it's now time for some questions. So if anybody would like to put them in the chat, or if you'd like to unmute and ask a question, then we're more than happy to try and respond. Okay, so question from Adam, which was about how enforceability will take place, and you see this as a major challenge. Adam, are you able to give us an example? Are you able to unmute yourself and ask the question in a bit more detail?
Sure. Can you hear me okay?
Yeah, absolutely, Adam.
So obviously it's a very broad question because you're dealing with a global phenomenon, and we'd have to drill it down into areas or specific countries or regions. But specifically in the Middle East, one of the significant issues around mediation in particular has always been the ability to enforce any decisions and how to make them binding. And my question really relates to whether you have any insight or experiences of the examples that you gave were very illuminating in terms of South Africa and India, etc. But in terms of countries or regions and how they're proposing to deal with the enforceability of any decisions that are online, we have significant issues in this region with even the ability to enforce an arbitral award between nations that have signed the New York Convention, unless various formalities regarding wet signatures and places where people sign awards, etc., are maintained. So I just think there's a big gap in the ability to get some of these online decisions enforced in significant parts of the world.
Yeah, I mean, you're absolutely right, Adam. There are still challenges about how many countries, not just the Middle East region, but other regions in the world, view the enforceability of certain agreements. And then when you add the online element to it, it does become complex. But our view, having spoken to many individuals and organizations around the world, is the following: that what COVID-19 has done to us is, even though we may return back to a new norm and the normal will change, it is going to evolve. The reality is that more and more of these agreements will be coming forward, and they will need a greater understanding from governments and from courts to assist the facilitation of enforcement. So I think even the idea of enforcement in post-COVID-19 with regards to the New York Convention, and then the development of the Singapore Convention, which is the alternative on mediation, will still evolve. I think that the jury's out, nothing is certain, but there's definitely moving in the right way.
Absolutely
I hope
agree.
that helps, Adam. We're not
No,
trying
it
to,
does. Yeah,
yeah,
there isn't.
yeah,
Exactly. There isn't one answer at the moment, and I think you're right. I mean, there are good examples in this region of governments moving very quickly to deal with other forms of society and dealing with that online. So I think you're right that the opportunity for rapid change in this space is there. I think, and the post-COVID world will, I think, be a catalyst for that. So I agree with you.
yes. I think, look, the what we've done in, I don't know, 15, 16 weeks of lockdown globally has been a pretty incredible achievement. We have one of our colleagues online here, Kim Courtley-Pell. She's a mediation trainer and part of our faculty. And just 4 weeks ago, one of the big arbitrations in London took place fully online. And she was the arbitration case supervisor. And what's really incredible is there was no choice. They had to find a way to navigate around this. And I think governments now and the courts are realizing that a lot of this work can be done online, and we need to find ways in which this can happen. So it really does work. But I hope that helps. And I think we received a lot of questions, everyone, from you. If you're online and would like to resubmit or ask your question, we'd be more than happy to take that. So just moving down.
Rahim, may I answer to Graham?
Please, yes, go ahead, Zoe.
Yes, Graham, thank you so much, first of all, for your question. And regarding the EU, the online dispute resolution platform, in order all of us to know, the platform was launched in 2016, and in order to be dealing with the 21% of consumers who face certain issues when making online purchases. So the thing is that the European Commission, of course, offers statistics on the provenance of disputes. And it's interesting to know that consumer confidence in e-commerce has increased by 21% as well in Europe since the launch of this platform. And actually, the most interesting statistic is the one that there is greater knowledge regarding ODR in general. So it's impressive that although there is no promotion actually from the states in a big scale, at a big scale, there is an increase in awareness regarding ODR. Still, as you mentioned, there is a lot to be done regarding this platform, and we are expecting that there will be an increase in the dispute on this platform. German people seem to be the most active on the platform, followed by the UK. And most disputes so far remain national regarding this.
Zoe, have you, great here, nice to speak to you again. Have you had an update on the figures? You say, when I last looked at the official figures, the UK, well, Germany was top with, I think, about 54% of companies complying. The UK was way down at the bottom half a dozen. Has there been, that was about 4 years or 3 years ago, has there, maybe there's been an update, has that put the UK second, which would be good? And the question is, how do you feel, what can be done about the fact that this system that the EU has set up is non-binding on companies, and apart from the companies that don't know about it, which is the vast majority, and don't comply by creating links, of course, even when they do, they don't have to participate in online dispute resolution. How do you see a way around this? Is this a private lobbying to business or public lobbying to the EU?
Well, yes, I will speak from, yes, thank you, Graham, and thank you so much for participating in this discussion. It's a big honor for us. For me, from the experience in Greece, and especially during the COVID, we received many complaints. And of course, as you might know, the most of them were against travel agencies, air tickets, cancellations and all that. So we see that it's been due to COVID situation, there was an increase, which of course gave us a lot of joy, because in Greece actually, and I will speak about Greece, but I know the numbers, the consumers are not familiar with the platform. The businesses are not familiar with the platform, and they are not linked to ADR dispute bodies. So the problem is that although we receive complaints from consumers all over EU, when we get in contact with the businesses, they even refuse to us to undertake to help them resolve the dispute. Either they prefer to the consumer to submit the dispute to the national bodies. So here we have two bodies in Greece, national bodies, for consumer disputes, where the resolution is free for both the businesses and the consumers. So of course, for consumers, we handle the disputes for the consumers for free as well, because this is according to the regulation in Greece. But the businesses have to pay the fee. So our big challenge, and I'm sure this happens in many other countries in EU, and I would like to hear your opinion on that, is that the businesses do not accept they don't want to be involved in this resolution. And this is where I think we have to have a boost from EU, I don't know how, in order to promote and establish more the platform. I don't know if it's a lobby.
Yeah, I think that.
I don't know.
Rahim, can you just mention, please, your course? If you'd like to, I would ask that you submit this to the International Council for Online Dispute Resolution, which has set up a training standards for training courses in ODR. I mean, a lot of people are just setting up courses and covering web conferencing, but of course ODR is about 95% more of it is more than that. But please submit it to the ICADER, because we'd welcome more courses, and it's quite a good initiative. Watch what what you are launching.
Great.
Thank you.
Well, thank you very much, Graham. We'll definitely be in touch with that. There are many other questions, and then we've got about 7 minutes, so I'd like to try and get through as many as we can. There's some good questions about people looking. There's one question I think from Nilmani asking about seeking online negotiation techniques. We run negotiation courses, so you're more than welcome to have a look at our website or get in touch by email with us to talk about that. Chitra and Amod, you're talking about the jurisdiction issues. One of the most important things about online dispute resolution is that the jurisdiction should always be determined before you go in. So just like the laws of an arbitration or a mediation to govern it, just because it goes online, it doesn't change the governance of the agreement, and therefore that's how you would go for enforcement proceedings. There's another question coming up from Angelos. EQ, or emotional intelligence and empathy, are critical for mediators in conflict resolution. How easy will it be for mediators to perceive the conflicting parties' emotions in ODR? Zoe, would you like to speak to that?
Yes, of course. We totally agree that EQ and empathy are critical in every way of resolving a dispute. I would say that mediating online is more challenging, and of course is more demanding. So there is a lot of preparation pre, during, and after the mediation, and part of this preparation is building this rapport with the parties, and be aware during the sessions that these skills, these communication skills are shown, are felt, are expressed with verbal and non-verbal communication during the session. But this is, of course, part of the whole training. So thank you for your question, Angelos.
Yeah, and I think there's another question similar, Zoe, from Pushup,
Yes.
which talks about the verbal, non-verbal communication, and is it really as effective as face-to-face mediation? Well, we both do online mediation, Zoe. What do you think?
Mm-hmm.
Do you think it's as effective?
I think, yes, at some point you forget that you have a screen in front of you. So the more familiar someone gets with this process, the more effective and the more competent becomes. And I can see the statistics, and we totally agree with this theory. So you can imagine that, again, this kind of communication needs a lot of practice and a lot of skills. Yes. Well,
yeah.
That visual material can never be. Mm-hmm.
Can I add to that, Zoe, just for a second?
Mm-hmm. Yes.
Which is many of you will feel that it could be seen as a second-class citizen, but one of the skills that we focus on in our training is the idea of digital empathy. Because one of the great things that we're good at is being empathetic in a personal setting. You know, we can make somebody pour a glass of water, we can offer them a handkerchief if they're a bit emotional. You know, we can do physical acts to show that we are engaged. When you go online, you need to start to learn this idea of digital empathy, which is what we teach in our online courses, and creating a digital presence. And once you have those two skills in the toolbox, as Zoe said, at some point you don't even realize you're behind the screen, because what you're doing is engaging in the content and receiving that responses from the mediator or a neutral that make you feel as if they were still next to you. And so these are really very interesting times, and new knowledge about neuroscience and about the role of technology helps us understand that this can be achieved, but it does take time. And also, if you look at digital natives, as Mark Prensky calls them, then it's inevitable to understand there is no difference to these individuals. I think there's a question about the courses that we offer and how much they cost, and can someone from a different background. We offer training to all types of people with different backgrounds, from law, humanities, sciences, etc. So they're really open to anybody. And the cost of the courses depends on where you take the course. But we have our first mediation course, as an example, accredited by the Civil Mediation Council and the Singapore Institute for Mediation in Dubai in July. So there's an option. But if you'd like to know a bit more, then why don't you email us on info@ADR ODR International, and we'll do our best to come back to you and actually help you understand what your best route to training is. Are there any other questions? Just having a look. I think we're hitting time as well. Zoe, any other comments you'd like to make?
I wish you had more time to delve into all this amazing field and use this platform as a think tank regarding ODR and dispute resolution. So I'm not sure we have. So thank you very much for your questions and your participation.
Yeah. Well, thank you to all of you. And thank you to the DIFC Academy for your generosity in accommodating this wonderful webinar and time to speak to everyone. Thank you to my colleagues Zoe and Kim. Zoe, for your excellent insight. I hope you have a lovely day in Greece, and to all of you around the world, stay safe, and we hope to connect with all of you very soon. Best wishes.